And so I want to introduce myself and welcome everybody. My name is Marisa Espinosa. I use she, her pronouns. I'm the public policy coordinator for Northwest Pilot Project. I have here Kelsey McGowan-Heilman, staff attorney for Oregon Law Center. And I just wanted to do a quick bit of housekeeping here before we get started with the training. It's great to see so many people here today for this training on tenant protections. I'm hoping it'll be useful to everyone. So yeah, I just wanted to once again say I'm Marisa Espinosa. You see my email on the screen. Feel free to email me at any time after this if you have any follow-up questions. My colleague Bobby Weinstock, he's the housing advocate with Northwest Pilot Project, and he is the one who started Housing Partnership Workgroup. He's still with Northwest Pilot Project in a part-time role, and so we just wanted to acknowledge he's not in the presentation today, but he's still around, and we thank him because he's the one who made this all happen. For newcomers, we wanted to give an extra warm welcome. We're really happy to have you here today. And we just want to acknowledge that due to COVID-19, we're all getting used to doing things differently to reduce the spread of COVID-19 and to keep ourselves and our communities safer. This is our first webinar. So any questions, comments, or feedback are very welcome. My email is on the screen. We hope everyone here is staying safe. We want to acknowledge not everyone in our communities is able to stay home or access PPE. So I know all of you here are taking time out of your busy days from working harder than ever before to achieve housing justice for our communities, and we just want to thank you. Before we get started, I do want to do a brief land acknowledgement. This is a new practice for Northwest Pilot Project, so please bear with me if I stumble over names. I'm just going to read a quick acknowledgement here. What we now call Portland, Oregon and Multnomah County were the traditional lands of the Multnomah, Cathlamet, Clackamas, Cowlitz, bands of Chinook, Tualatin, Kalapuya, Molalla, and many other tribes who made their homes along the Columbia River. Today, people from these bands have become part of the Confederated Tribes of the Grand Ronde, Confederated Tribes of Selets Indians, as well as the Chinook Nation and Cowlitz Nation in Washington State. We also acknowledge the systemic policies of genocide, relocation, and assimilation that still impact Indigenous and Native American families today. Many here today are settlers and guests in this land, and we acknowledge the work of Native nations, leaders, and families, as well as Indigenous knowledge, creativity, resilience, and resistance. And now I want to go ahead and pass the mic to Kelsey McGowan-Heilman. She's here to do the presentation. Kelsey, thank you again for being here to do this training on tenant protections.
Hello, thank you so much, Marisa. So thank you all for being here. I am here today to talk about some recent changes to the law related to tenants' rights in Oregon. And as I'm sure you all know, a lot has happened recently. So we're going to cover a lot of ground between now and 4 o'clock. I'm going to do my best to answer questions. We will not possibly be able to get to all the details, but we're going to do our best to give everybody a clear overview of the main things that are going on and answer basic questions. Next slide, please. So I am an attorney with Oregon Law Center, which is a statewide provider of civil legal assistance to low-income Oregonians. We don't charge our clients for our services. And we handle a variety of cases. So there's a list there on your screen. We do a lot of housing work focusing on evictions and discrimination, but we do habitability cases and other things related to housing as well. Oregon Law Center has a bunch of different offices across the state, and those offices take family law cases, employment cases, public benefits cases, civil rights, consumer cases. We, I think in all of our offices, if not all our offices, then certainly the offices in the Portland metro area have staff that are fluent in Spanish, and we use language line to serve clients who speak all different languages. So please keep this in mind if you encounter low-income folks who have legal needs. And you'll see there's like a pink line drawn around part of the map of Oregon there. That is the service area that my office, the Portland Regional Office, handles. So it's quite a few counties and a lot of the population of the state. We work in close partnership with all of the offices across the state, including the Hillsborough office, which serves Washington County and the coast, and the Eugene office, which serves Lane County and a bit further south. Next slide, please. So I have to give this disclaimer every time I give a presentation, but it is especially important in a situation like this where there are 103 people on the call. I am not your lawyer. This is not legal advice. I cannot ethically give legal advice in this call. And so what does that mean, or in this presentation? What does that mean? It means I can provide legal information and I can answer your questions about these laws. I cannot give you advice about what a person should do in a specific situation. I can answer hypothetical questions, so those are okay, but I can't advise you about what's going on in an actual situation where you or someone you know is trying to make a decision. If you want legal advice and you are a tenant or you know someone who's a tenant, that person can call Oregon Law Center or our sister organization Legal Aid and go through the intake process, and we may be able to we will be able to provide information, and we may be able to provide more extended representation. If you want legal advice and you are a landlord or a housing provider, you will need to call the Oregon State Bar for a referral. So if I get a question that seems like it's going across the legal advice line, you might hear me say, I'm not going to be able to answer that in this context. We would have to have a private conversation, and that's why. Next slide. So what are we going to cover today? We are going to cover the COVID-19 tenant protections, the eviction moratorium just passed by the legislature and signed by the governor, the rent repayment rules that accompany that eviction moratorium, and then the new Portland ordinances on tenant screening and security deposits, which went into effect on March 1st. Next slide, please. So let's start with the COVID-19 eviction moratorium. So this is House Bill 4213, which passed during the special session on June 26th and was signed by the governor on June 30th. The eviction moratorium applies everywhere in Oregon, and it applies to all landlords. And the rules are that there can be no evictions for non-payment or for no cause between April 1st and September 30th, 2020. And then that's followed by a 6-month repayment grace period lasting until March 31st, 2020 to pay back any deferred rent that was not paid between April 1st and September 30th. We will go into detail about what that means. If a landlord violates this moratorium, a court can order the landlord to force the landlord to allow the tenant to move back in, issue a court order saying the tenant gets to move back in, and award the tenant up to 3 months rent and damages. Next slide, please. So here are the details. Until October 1st, 2020, the eviction moratorium says that landlords are not allowed to give a termination notice for non-payment of rent, fees, utilities, or other charges, charge any late fees or penalties for non-payment of that rent and fees, give a termination notice without cause. The exception to this one is if the landlord sells the unit who plans to move in and occupy the dwelling himself or herself. Start an eviction case based on non-payment or termination without cause. File for non-compliance with a stipulated agreement in eviction court if the eviction was based on non-payment or termination without cause. So this is for eviction for non-payment, termination without cause that predate April 1st, and there's a stipulated agreement that involves some sort of coming back into compliance. And the landlord cannot report a tenant to a credit agency for non-payment of rent or a late fee. Yes, good question. Should the payment grace period be through March 2021? It should. It is not through March 2020. You have until March 2021 to repay the back rent. Thank you for that question. Okay, next slide, please. So these are the details on the rent repayment grace period. Starting October 1st, tenants are going to have to pay rent for each month at the usual time. So October 1st, rent is due in full on October 1st or whenever it's due under the contract. And the landlords can charge late fees or penalties. And if the person doesn't pay and the landlord goes through the proper process, they could initiate an eviction case for non-payment of rent for October rent. For the back rent between April 1st and September 30th, tenants are going to have until March 31st, 2021 to repay. So it's a 6-month grace period from the expiration of the moratorium, and actually a full year grace period for rent that wasn't paid in April. Landlords can lawfully send a notice stating to the tenant how much rent is owed. And landlords can also lawfully in October ask a tenant in writing to say within 14 days of the notice whether the tenant will be using the 6-month grace period to repay. And it is really important that tenants respond to this notice. They can respond by text, email, letter. Verbal is okay, although I always advise doing something other than verbal so that you have some proof, because the landlord can charge half a month rent as penalty if the tenant doesn't provide that information within 14 days. And just as backdrop, one of the most basic pieces of advice that we have been giving clients during this time is stay in contact with your landlord and tell your landlord what is going on. That is going to make it much more likely that all of this will go smoothly. Evictions for non-payment of rent, like I said, are allowed after October 1st if it's about rent due October 1st or later. But evictions for non-payment of rent from April to September, what this grace period means is you can't evict for non-payment of rent during that period until April 1st, 2021. So there's a question in the Q&A, what does a tenant do if they're given an eviction notice for a cause, but there is really not a cause, the landlord is making it up. So this is a common issue for tenants that is not necessarily specific to COVID. This can arise in other situations as well, but I think the suggestion is right that it may arise more commonly now for tenants who are behind on those 6 months of rent. And the answer is that is definitely a situation when it would be a good idea to talk to an attorney. Call Oregon Law Center, call Legal Aid Services of Oregon. We would need to gather some more information about what's going on. The other thing that is super important to tell tenants always, always, always is keep copies of everything. Make sure that if you're communicating with your landlord to the extent you can, it's in writing. Text messages are great as long as you save them. So it's just important to have good documentation of what's going on. And then there's another question, what efforts are being made to get this information to the public, especially through channels that may be utilized by people in this circumstance? So with respect to what Oregon Law Center and Legal Aid Services of Oregon are doing, we have information up on our website, Oregon Law Help, which has a lot of self-help materials. There's also for Portland specifically, I think it's Oregon Renters' Rights that has information, and that's run by Legal Aid Services of Oregon's Portland office. We have YouTube videos out. Those are going out on social media. We have 1-pagers and 2-pagers going out in multiple languages. Those are also going out on social media challenges. But we would love everybody's partnership in spreading the word. And I encourage you to go to Oregon Law Help to see if there are materials there that you would find useful in helping to communicate with whatever client communities that you serve. Next slide, please. Okay, so I'm going to move on to talking about the Portland Security Deposit Ordinance now. The citation for this is Portland City Code 30.01.087, and it took effect March 1st, 2020. It applies only to tenancies in the Portland city limits, and portlandmaps.com is a good resource for finding out if an address is actually within the Portland city limits. Just because you write Portland, Oregon when you mail something does not necessarily mean that the address is in the Portland city limits. The ordinance gives new tenant protections at move-in, during the tenancy, and at move-out, and we're going to talk more specifically about what those are. Most provisions apply only to tenancies that are begun after March 1st, 2020, but there are some provisions that apply to all tenancies, including tenancies that were already in process as of March 1st, and so we'll talk about that too. The remedies, if there are violations, the tenant can get double their security deposit, attorney's fees, and costs if they have to go to court. Next slide, please. So there are a bunch of different things that this ordinance does. The first one is that it regulates how much a landlord can charge for a security deposit. So landlords can't charge more than 1.5 times the monthly rent if last month's rent is part of the deposit, or 1 month's rent if there's no last month rent as part of the deposit. Except, and you'll see both this and the tenant screening ordinance are quite complicated. If the tenant, when they apply, has their application would ordinarily be rejected under the screening criteria that the landlord uses, the landlord is permitted to charge an additional deposit of up to half a month's rent in order to approve that otherwise denied application. But the landlord must allow payment of that 1/2 month rent in installments over 3 months after the tenancy starts. Landlords also have to put security deposit funds in a separate federally insured bank account and tell the tenant in the rental agreement where the funds are held. Separate bank account does not mean that there needs to be a separate account for each tenant's security deposit. It just means that the account has to be separate from the landlord's personal account and from the landlord's general business account. There has to be a special account where the only thing that happens there is security deposits are going in and out. If the account earns interest, it's not required for it to be an interest-bearing account, but if it is an interest-bearing account, the tenant gets the interest minus an optional 5% deduction by the landlord. 5% of the interest, not 5% of the balance. Next slide, please. Okay, so if a landlord plans to include fixtures, appliances, or equipment or personal property in what's covered by the security deposit, then the ordinance requires the landlord to describe and provide current depreciated value in the rental agreement. So what that means is if the landlord is going to include an oven or a stove, then the rental agreement has to specify that that oven stove is included, provide information about the condition of the oven or stove, and depreciate it according to a schedule that is provided by the city. In addition to that information, there are provisions that have to do with a condition report upon move-in. So within 7 days of moving in, the tenant has a right to, but is not required to, submit a condition report to the landlord. If the landlord reviews that condition report and there is a dispute, then a neutral third party reviews the condition report. If there is no tenant condition report, if the tenant does not provide a condition report within 7 days, the landlord has 17 days from the date of move-in, so that's 10 days after the 7 days expire for the tenant, to provide a condition report with digital photographs, and the landlord has the obligation to update the condition report with repairs during tenancy. Next slide, please. The security deposit funds, there are also restrictions in the ordinance on what you can use security deposit funds to pay. So basically, they can be used to pay the actual costs of returning the rental unit to the condition it was in at the time of move-in. So you cannot use security deposit funds for routine maintenance or ordinary wear and tear, damage not caused by the tenant, costs reimbursed by insurance, painting the walls or cleaning or repairing of the carpet or flooring, except in certain narrow circumstances where the damage goes beyond ordinary wear and tear. And for tenancies started after March 1st, 2020, you can't use the security deposit to cover damage to fixtures and appliances that aren't described and depreciated in the rental agreement. So the first 4 bullets there, that's an example of one of the provisions that applies even if the tenancy started before March 1st. As of March 1st, you can't use security deposit funds except according to those rules. Some of these rules are duplicative of requirements that already exist in state law, Chapter 90, and some of them are stricter. Next slide, please. The tenant has a right to a walkthrough at move out and a right to receive a notice of their rights under the Portland Security Deposit Ordinance, and there's a form available from the City of Portland that landlords can use, along with the final accounting or return of the security deposit, which is due within 31 days. And then within 5 days of any request from the tenant or notice from the tenant or landlord of intent to terminate the tenancy, the landlord has to provide a written rent payment history and an accounting of rent due to the tenant. Next slide, please. Okay, so before we go to the Portland Tenant Screening Ordinance, I'm going to pause there. Are there any questions about the security deposit ordinance? Okay. So this is our third topic for today, the Portland Tenant Screening Ordinance. And this is the most complicated of the 3 laws that we are discussing today. We will not be able to cover all of the rules. We will not be able to get into all of the details, but I hope to give you an overview that's sufficient to answer your question. So this is called the Fair Ordinance, Fair Access in Renting. It, like the Security Deposit Ordinance, is effective March 1st, 2020. Unlike the security deposit, which just applies to all the security deposit ordinance, which just applies to all tenancies in the Portland city limits, this ordinance applies to tenancies in the Portland city limits, but it does not apply to certain arrangements where the landlord is also living on the property. So like the landlord is the roommate, or it's a duplex and the landlord lives in one unit, or there's an ADU that the landlord lives in, or the landlord lives in the big house and somebody else lives in the ADU. This screening ordinance does not apply to those situations. And also, it doesn't apply to certain regulated affordable housing. So this applies to a narrower set of units, but still to the majority of units that are available in Portland. Next slide, please. So first I want to talk about the requirements that this imposes for advertising. Basically, broadly speaking, the ordinance says you have to advertise ahead of time before you actually start accepting applications. And then we're going to talk about how there are rules that have to do with how you accept applications in order and considering those applications. So the rule is that you have to the landlord has to advertise for 72 hours before starting to accept applications. And that advertisement has to include the date applications will be accepted, the screening criteria that will be used, and whether the unit is accessible for people with mobility impairments. The screening criteria can sometimes be lengthy, and so it's okay if the advertisement includes a link or instructions for how to access those screening criteria. The advertisement itself does not have to enumerate all of the screening criteria. Landlords are allowed to maintain a wait list, but those wait lists also must be advertised for 72 hours before applications open up. There are special rules that apply when a multi-unit listing is going live. So if an apartment complex has more than one unit available, then the advertisement also has to include information about the number of bedrooms in the different units and some other things like that. Next slide, please. So the landlord, after the 72 hours, when they start accepting applications, has an obligation to mark applications with the time and the date they are received, and the applications get processed in the order received, except for two exceptions to that rule. First of all, applications received prior to the date and time the landlord advertised accepting applications are treated as if they were received 8 hours after the open enrollment started. So the person who applies within the first 8 hours of the open enrollment actually becoming active has their application considered sooner than someone who applies before the open enrollment period begins. And if the dwelling unit is accessible to folks with mobility disabilities, then any applicant with a mobility impairment who applies in the first 8 hours gets priority over all other applications. If you have multiple people who meet those criteria, so for example, if you have multiple people who applied prior to the date and time the landlord advertised accepting applications, then you treat those all as received 8 hours after open enrollment started. And within that batch, you evaluate those applications in the order they were actually received. Same with the accessible unit. Any applicant with, all applicants with mobility impairments who apply in the first 8 hours get priority over other applications, and you evaluate the applicants with mobility impairments in the order in which the applications are actually stamped received. It is okay for a landlord to require proof of identity, but the ordinance makes it illegal for landlords to ask about immigration status of the applicant or family members unless that information is required to determine subsidy eligibility. Next slide, please. Okay, so the tenant screening ordinance then imposes a set of screening criteria that apply to everyone, and landlords cannot opt out of these screening criteria. And then, as we will talk about after that, landlords have a choice in terms of screening criteria. So we're going to talk first about the criteria that apply to everyone. So before I can explain these rules, I have to talk a little bit about median household income and affordability. So some of these requirements are tied to rents that are deemed affordable to households at 80% median household income. So for 2019 in Portland, this means $1,320 a month for a 1-bedroom, $1,584 a month for a 2-bedroom, and $1,829 for a 3-bedroom. So if the rent is below that threshold, those numbers I just stated, then the landlord can require the tenant to show income up to 2.5 times the monthly rent. If the rent is above those numbers, then the landlord can require the tenant to show only income up to twice the monthly rent. The landlord is obligated to consider all sources of income and compare to the share of the rent that will actually be paid by the tenant. So for example, if the apartment rents for $1,500 and the tenant is going to get a $1,000 a month subsidy, then the amount that the tenant has to pay is $500. And so depending on whether it was above or below that median household income level, it's possible that $1,250 a month or $1,000 a month of income would be required. The tenant has the authority to choose, the applicants have the authority to choose which tenants will be screened for financial eligibility and which will not. But everyone who lives who is applying to live in the unit can be screened for other reasons. So for rental history and criminal history and all of that stuff. But the financial eligibility criteria, the applicants are allowed to say these folks are going to be the financially responsible ones, these ones are not. So please screen just these folks. We have a couple of questions here. Well, all of these current elements are Portland specific. I wondered about any assistance statewide that landlords can access for their lack of income from deferred payments. And are landlords allowed to give notice to tenants confirming they have not received their rent monthly? I'm writing since I know someone who paid rent late and were given a non-payment statement. It didn't threaten eviction, was an official form that appeared intimidating. So 2 questions there. There are resources available to help some landlords bridge the gap. Those resources are being distributed much like the rental assistance resources at the community action agency level. And so it's going to be county specific, and you can reach out to the government wherever the person lives to find out how to apply for those resources. But there is assistance available for landlords who are facing, for example, foreclosure consequences, although there are also foreclosure protections in the eviction moratorium. Landlords are allowed, landlords are allowed to give written notice to tenants saying this amount of rent is unpaid. That's okay. I think whether a given notice crosses the line into something that is effectively threatening eviction would be a fact-specific inquiry, and you would need a lawyer to look at the notice to see if it was okay. But a statement that rent is not paid is permissible under the eviction moratorium. Do landlords have to consider SNAP as income? No, so you consider income that is, I'm sorry, all sources of income that are available to pay rent. And because SNAP is not available to pay rent, then I believe it is not counted as a source of income. I can double check to make sure that that's true. Let me make a note of that and follow up. But I do not think that, I'm sorry. There we go. I'm gonna make myself a note here. I will find out the answer to that question and I will provide it to Northwest Pilot Project, and I'm sure there's like a list it can be circulated to. Okay. Helpful information about the median household income and affordability. So a bit higher than the numbers I just gave: 1 bedroom, 1,382, 2 bedroom, 1,658, 3 bedroom, 1,916. And that information should always be available on the Portland website, on the City of Portland website that has information about this. Thank you for providing that. Do the 2.5 monthly income requirements apply to tax credit properties? So let me get into the rules a little bit on the affordable housing that is not subject to this ordinance. Oh, okay. So I see an answer in the chat. Thank you. So Fair Housing Council of Oregon, which I trust to have the right information on this information, says that SNAP benefits should be counted toward the total household incomes during screening. So I will follow up and make sure that's true, but I'm sure if Fair Housing Council of Oregon says that's the case, then that is the case. There's also another question in the chat. I'd like to ask folks to use the Q&A feature, just because it's hard for me to track things that are happening in 2 locations at the same time, but I will answer this question. When a landlord advertises and they say nothing about accessible units, does that mean that they don't have any? It should. They are required to say whether it is accessible, and it would be a violation of this ordinance if they did not make that disclosure affirmatively in the advertisement. So I'm going to come back to this 2.5 monthly income requirements question. I'm sorry. I thought I had more detailed information about which affordable housing providers this applies to, and it does not. I can follow up with some information about that as well. So I will include that in communications that go out after. Okay. In October, does the landlord have to apply the payment to current rent or past due rent from previous months? So October rent is what's due. I think the best practice here would be for tenants to very clearly state that they are paying the current month's rent first, October month rent first, and then anything extra to the back rent. I don't believe that the eviction moratorium is incredibly clear on this point, but I think a landlord who tried to apply a payment made October 1st to the back rent and then evict for non-payment of October rent would be in violation of the eviction moratorium. But it's good advice to tenants to be very clear that you want your rent payment applied first to the current month and then any extra payments that you make to the back rent. Okay. All right, next slide, please. Okay, so those are the requirements that apply to everyone. And now from this point, landlords have an option. They can either adopt low barrier screening criteria, which are set out in the ordinance, or they can choose to apply their own screening criteria consistent with state and federal law and conduct an individualized assessment. Under both approaches, within 2 weeks of processing the application, the landlord has to provide written notice of acceptance, conditional acceptance, or denial, and has to give reasons for the conditional acceptance or denial. And also under both approaches, there's a 30-day window to appeal. The landlord has to set up that appeal process. And if the person is successful on appeal, then there's pre-qualification for rental opportunities and waiver of the screening fee for the next 3 months. Next slide, please. The Portland Tenant Screening Ordinance, low barrier screening criteria include the following. For criminal history, there can't be denials for arrests but no conviction. That's actually already in state law. Misdemeanors that are 3 years old or older, felonies that are 7 years old or older, juvenile convictions or convictions for crimes that are no longer illegal in Oregon, like marijuana possession. And the applicant has the right to submit supplemental evidence to explain any disqualifying criminal history. That could include evidence about substance abuse or mental health treatment that postdates the conviction and might be seen by the landlord as mitigating. There are credit history rules, so there can be no denials for a credit score that is higher than 500, insufficient credit history, less than $500 owed to prior landlords for property damage, discharge, bankruptcy, or medical or educational debt. And there are rules around rental history. So there can't be denials under the low barrier screening criteria for insufficient rental history, evictions that are 3 years old or older, negative former landlord references unless it's about failure to pay rent, or 3 or more documented written notice material violations of the lease within a year, or money owed to the current former landlord, or a lease violation in a for-cause notice. So limitations on when you can take that negative former landlord reference and use that as a reason for denial. And we have a couple questions. I'm going to get to the question about October rent. I'll go back to that at the end, but since we're in the screening criteria arena, I'm going to answer those questions first. So does a landlord have to give all reasons for denial, not just the primary reason? I mean, the landlord has to give the reasons for the denial. I suppose if any one reason that is disqualifying under the screening criteria is sufficient, what that means though is that if the person appeals and that reason turns out to not hold water, then they're going to be pre-approved and have the application fees waived for the next 3 months. And then landlords will say when someone is denied, contact the screening company, and the screening company says contact the landlord. So landlords can't, they have to make sure it is on the landlord under this ordinance to make sure that a statement goes to the tenant giving the reasons. So there can't be that football back and forth. The tenant gets to know what the reasons for the denial. I don't think that's going to obviate all problems with background checks. There's often bad information in background checks, and that's a whole other presentation. But the landlord has the obligation to give the reasons, and it is not a reason to say you failed screening, talk to the screening company. That does not satisfy the requirements. Landlords can evict in federal housing for marijuana possession still, yes. Okay. Next slide, please. So that was the low barrier screening criteria. The other option, landlords do not have to choose those criteria with respect to criminal history, credit history, and rental history. They can instead choose their own criteria as long as those criteria are consistent with Oregon law. So some of the things that I just listed, like you can't deny for an arrest that didn't result in a conviction, or for an eviction judgment that has been sealed, that's in state law, and that applies to everybody. But landlords can choose, for example, that they want to deny for felony convictions more recent than, or that are older than 7 years old. Before denying, they have to conduct an individualized assessment of the reasons for the denial, the landlord, and consider any supplemental evidence presented by the applicant. And then the denial notice has to give both reasons and explain why the supplemental evidence did not change the decision. And I will note here that there are fair housing issues involved in applying inflexible rules that have to do with criminal history because of disparate impact on the basis of race. So I'm sure, I know this is a common thing that landlords have to seek legal advice about. And that's just a note about how federal rules can come into play even for someone who's choosing the low barrier. Does the landlord have to provide any information to the applicant about what type of supplemental evidence they would like to see? No, but it would be a good practice for landlords to do that if they are interested in helping people to connect with affordable housing. But the supplemental evidence rule, the landlord has to accept and consider supplemental evidence, but it is not the landlord's job to ask for that supplemental evidence. It is on the tenant to submit the supplemental evidence. Okay, next slide. Okay, so we have made it to the end. So I'm going to go to the last question that's in the Q&A, which is, if October rent is less than the full amount or late, then the moratorium rules do not apply. And what I would say about that is, if October rent is less than the full amount or late, then the landlord can follow usual rules for evicting for non-payment of rent in October. The moratorium rules still apply in the sense that you cannot be evicted for not paying the rent from April to September in October or November or whenever the action is being taken. But with respect to October rent, in the absence of additional legislative action or governor's action or something, the rules go back to the way that they were in terms of rent being due, late charges being assessed, and the availability of eviction proceedings. There are 30 days to appeal. Now, I understand what you're saying. The landlord does not have to hold the unit vacant during that time. The landlord is not under obligation to hold the unit vacant for any period of time once application has been denied. And so instead what happens is, if the person is successful on appeal, then they get pre-qualified for a unit that comes open from the same landlord with the application fees waived for the next 3 months. How long can landlords take to provide an answer about an application, and how long can they take to make a decision about an appeal? So the application is 14 days, I believe. From 2 weeks of processing the application, then you have to make a decision on the application. I do not know the answer about the timeline to make a decision on appeal, and I will look at the ordinance and see if there are timelines regarding decisions on appeal and follow up.
Thank you so much for doing that, Kelsey.
Sure, there always are, especially with new laws, there just always are questions that I am that I don't know the nitty-gritty on.
For sure.
Okay. Can the landlord deny an applicant for a negative reference that is less than 3 years old? So I would need to look at that. I did not say that clearly, and I need to look to see if there is a time frame tied to the negative references piece. Oh, I'm sorry, that is less than 3 years old. Yes, they can deny for a negative reference that is less than 3 years old, but only if they are choosing the low barrier screening criteria. Then there are rules about the type of negative reference that can be taken into account. So a negative reference that is about unpaid rent, or about 3 documented material lease violations, or a documented lease violation plus 4 cause eviction initiated, is okay. Other types of negative references under the low barrier screening criteria are not okay. So for example, if the former landlord says like, oh, they were always violating the lease in like X, Y, or Z way, but none of those were actually documented and written up, then under the low barrier screening criteria, you cannot deny for that reason. If the landlord chooses something other than the low barrier screening criteria, then they can take negative references into account that are less than 3 years old, and they don't have those same rules attached, but they're going to have to provide the reasons and the explanation about the supplemental evidence. Yes, the 2 weeks is just on the screening, just on the processing of the application. Okay, next question. How are 4 cause evictions happening during COVID? Are courts considering only severe cases now and deferring cases that normally would have been seen? And are they just backlogged? Yes, yeah. So courts are just not having eviction. I mean, you can file a 4 cause eviction case, but courts are not convening proceedings on those, to my knowledge. Right now, I mean, certainly I'm most familiar with Multnomah County. Multnomah County is not holding proceedings on 4 cause evictions unless it's a serious sort of health safety, like a 24-hour eviction. Then you can get some sort of expedited review. But regular 4 cause for lease violations or whatever, I think they are just stacking up. And then I assume much of the legal process is done via telecommunication. I don't know if there's more policy flexibility than there's times. Yeah, my understanding is they're just still not, it's not a priority, right? So I cannot speak to the eviction, the decisions that courts are making across the state, because I only practice in a certain area of the state, and I practice primarily in Multnomah County. And in Multnomah County, the court still has like a set of priorities in terms of the proceedings that it is convening. And my understanding is, other than emergency situations, the evictions are just stacking up if they have been filed. Okay, if someone is receiving a housing subsidy that is temporary, can a landlord deny the applicant if they would be entering a 12-month lease stating that the applicant would not meet the income requirements after those 6 months? Yes. Yeah, so they're allowed to evaluate financial eligibility for the full period of time. And although they have to consider all sources of income, they're allowed to consider when those sources of income will be available. Next question. Do landlords have to disclose whether they're using low barrier screening or not in their advertisements? They do. They must say which criteria they are using. And if they're using the low barrier, it has to say that in the advertisement. And if they're not, there need to be written criteria that are available to applicants to look at. And whether that's part of the advertisement or there's a link or direction to go somewhere else to look at the screening criteria, it is required that tenants are able to see what the criteria are before they apply. That's important so that people don't apply for units they're not going to qualify for. And it also is important so that folks can know if they need to submit supplemental evidence. Okay. Any other questions? These were all very good. Okay.
Questions.
Yeah, so I have a set of things I'm going to follow up on. Oh, another one. As unemployment benefits under the CARES Act become less, can landlords deny an application today if the benefits have not expired yet? Wow. What a great and complicated question. Boy, unemployment benefits. I have never thought about how considering unemployment benefits as a source of income would play into evaluating eligibility for housing. I will do some thinking about that and see what I can provide. I think that the answer is that they would look at proof of the unemployment benefits that the person is receiving right now, and then assume that when the cliff happens in August, that income would drop, and they're not obligated to assume the person would get a job or would have something else intervene. Wow, that's a great question, and another part of the unemployment horror show that I hadn't considered. Okay. I'm going to write that down and see. I'll think about that and see if there are other things to.
Yeah, and if I could just chime in as a non-legal expert, just in my experience working with folks accessing housing, there have been times where screening criteria normally would talk about whether income was temporary or not, that type of thing. So that may already be kind of a consideration, not just because it's CARES Act. Income.
For sure. They're asking at the moment to put unemployment as income, someone says. I mean, unemployment is income, and there are ways to figure out what someone's benefit will be and how long it will last. And so it seems, there is an obligation to consider all sources of income. The problem is that that the CARES Act benefits are going to be reduced. Yes, UI benefits expire at 26 weeks with a 13-week lesser extension, but there's also extended benefits. But it's true that people are not going to be getting unemployment benefits for a full year. So that's a good point, that if you're looking at yes, extended benefits is even less than pandemic unemployment assistance. But the question is a good one. I mean, I think there are a lot of people who are going to be including some amount of unemployment in their income, and even small amounts can make a difference in terms of qualifying. Okay, any other questions? Please feel free to reach out to me directly. If anyone, I am always happy to talk to tenants advocates and people who are working directly with clients if they have questions. And did I put my contact information on that second slide? I think I did. No, I didn't. Okay, well, so I'll send that out in an email too. I will provide the intake line from my office. I ask that if you're going to share that with potential clients, you share our intake line rather than my direct line, because we have intake and screening processes. Unfortunately, we can't represent everyone, even everyone who's financially eligible for our services. Rachel is asking great questions, and I do not have an answer to them. So how is this sustainable unless everyone gets magically employed again, and how alone can people possibly ever pay this off? I will tell you the truth. I think we are facing really serious fallout when the repayment period ends in the spring. In Oregon, we are in a better situation than a lot of other states that don't have an eviction moratorium, never had an eviction moratorium, and never had it had no repayment guarantees. The legislature is thinking about and going to be providing rent assistance, and there's CARES Act rent assistance that is coming through. I think a lot of the participants in this group actually are going to be handling the applications and communicating county by county with getting folks connected to rent assistance. But I totally share your concern. I don't think it's enough. One important point about the CARES Act rent assistance, there was a fight about whether immigration status played into eligibility for that relief, and it does not. So folks, regardless of immigration status, should be able to apply for that CARES Act relief when it comes available. That's an important message to spread in the community. I think that the legislature is likely to be providing some additional rent relief. But I totally agree with you, Rachel. I'm worried it's not going to be enough. We have a lot of work to do, basically. All right. Thank you, everyone. I'm so sorry that we can't be in a room together so that I can meet everybody in person. But I hope that you will keep Oregon Law Center in mind as you talk to tenants who need help. And I will do one final plug, which is that we not only represent individual tenants, we also do impact work. If you if you find out about landlords in your community who are not following these rules, like not just for one person but for lots of people, we are especially interested in those cases because we can take action that can change things for a larger group of people.
Thank you, Kelsey. And yeah, big thanks to you. Just want to say again, that was an excellent presentation. I think it's going to help a lot of the folks here and folks who weren't able to tune in as well, hopefully. I wanted to thank folks who attended. Before we wrap up, I just want to point again to my email address on the screen right now. Please send me an email. I actually just got a couple while we were talking for people who aren't on the mailing list. So please email me if you're not on the list, I'll add you. And if you just have logistical questions or have any feedback about access to this webinar, we want to make it as accessible as possible. I already have some new ideas from just the past 55 minutes. So thank you so much. I really appreciate everyone who's been a part of this today.